You may proceed.
Chief Justice Hunstein, Presiding Justice Thompson, members of the court. If it please the court, my name is Manny Arora, and along with Steve Scarborough, we represent the defendant Michael Registe in this matter. I'm here in an interlocutory basis with undisputed facts, requesting a de novo review as to whether the trial court erred when it denied the defendant's request to suppress cell phone records and the derivative evidence derived therefrom as part of this double murder investigation done by the Columbus Police Department. As stated in our briefs, we find that the error exists in this case because the judge incorrectly found that the Fourth Amendment was not violated. And secondarily, if the Fourth Amendment was violated, there's no remedy according to the trial court's order under Georgia law or federal law. We would submit that the trial court was incorrect on both these counts. Specifically, the case law that's cited by the trial court in its order mirrors exactly what the prosecution submitted to the court word for word as in the interlocutory appeal brief that was filed by the state. There's nothing wrong with that. The problem here is the judge wasn't given all the evidence or all the research that would be accurate. Specifically, at the time the judge is citing Smith versus Maryland and other privacy cases that correctly said at the time that you don't have a privacy interest in your cell phone records, that was fine, and that was 86 or prior to that. OCGA 161166.1 was enacted in 1993 and most recently amended in 2002. What OCGA 161166.1 does is it gives our citizens additional protections to include cell phone records as a privacy basis. North versus State from the Georgia Court of Appeals in 2001 says specifically, Georgia law must meet the minimum privacy protections of federal law, but the state may impose more strict standards or more protections for our citizens. That is specifically and exactly what we did in OCGA 161166.1, which gave us per se privacy protections with regards to your cell phone records, cell tower locations, and things of that nature are specifically referenced. What Justice Thompson correctly wrote in 2011 is, moreover, it is presumed that all statutes are enacted by the General Assembly with full knowledge of the existing law, including decisions of the court. Your Honor wrote that in Flores versus Express It last year. And what that means is when the legislature passes a statute, we are presumed to know every case and every statute that existed before it, and by doing so, we are changing the law. Specifically, 25 years ago in Mullins versus First General, this court stated, we must conclude that the General Assembly took cognizance of its prior enactment of the case law construing it, and that its purpose was to alter the law. What our briefs have said and why the trial court erred is it is taking inconsistent or inapplicable law in this matter as to the cell phone records when it's made its rulings. The state cites a ton of string cites from multiple unpublished district court opinions throughout the state in the 2000s, throughout the country, excuse me. The trial court took that verbatim. The problem is when you read those string cites that the state has given to the court and it was put into its order, none of those cases involve 18 U.S.C. 2703. That is the specific statute that Georgia 161166.1 references when figuring out how one goes about to get cell phone records. In fact, the cases cited by the court in all those string cites with all the different district court opinions that are unpublished never once dealt with that, and the reason they didn't is they all involved either a subpoena, a search warrant, or a court order. Those are the three, without any exception, the only way we can get cell phone records of individuals in the state of Georgia. 161166.1A specifically says we must follow federal law. 18 U.S.C. 2703A, B, and C specifically give us three prerogatives on how we go about doing it with no exceptions listed therein.
What about 2702?
2702, Your Honor, would include the emergency exception.
Right.
What you will have before the record is a complete lack of why the provider, the cell phone provider in this case, would be able to exercise the emergency exception in this case. There's not a single word as to what was going through the cell phone provider's mind at the time to incorporate 2702, the emergency exception. It just didn't exist. There's no facts on the record to say it. I would further argue when we look at the emergency exception, when you read 2702, the language almost mirrors what we would call exigent circumstances. And we know under the case law that deals with hot pursuit, immediate, imminent harm to someone, things of that nature. What you have here is the murders took place on the 20th of July.
I mean, you say that, but that's not how the federal courts and federal law enforcement authorities in practice have use 2702. The most common example of 2702, I think, is kind of kidnapping cases where the provider provides the information, sometimes unsolicited, or solicited with a phone call. So it doesn't have to be a hot pursuit. It can be. I mean, kidnapping doesn't give you the right to go search anybody's house because you feel like it, but it has been used to get an emergency order.
I would
You have to give me something more than it's like exigent circumstances.
Justice Namias, what it's talking about there is you have to have a basis for why you think it's an emergency when you disclose it. OCGO 1611 66.1b says specifically a provider may turn over records if the government has met its compliance under federal law, thereby showing that there's some emergency that exists. And when you look at the definition of the word emergency, it's
Actually, 2702, you don't even have to have a government request. The provider can do it on its own, right?
Yes, Your Honor, but the Georgia statute, which gives you the additional protections under subsection B of 66.1 specifically says, if the government has met the federal criteria, then the provider can give it over. 2702, when you look at the cases, Justice Namias, really deals with the federal civil protection for those cases so that everybody's not getting sued. The primary case I've found is Friedman versus AOL, Young and Bensi. Those are two officers. It's a 303 Fed Sup 2nd 121. It's a 2004 case. And in that situation, there was a kidnapping, as you pointed out, Justice Namias, where the victim escaped and went to the police. They requested the cell phone records and they were turned over. The difference there is the U.S. attorney in that case presented evidence as to why the provider in that case thought there was an emergency in turning them over.
But in Friedman, they said it wasn't appropriate, and they said the reason was it's not like the faxed request here that says request, but they basically faked up a search warrant, never got the judge to sign it,
Yes, sir.
and sent in what looked like, except for the lack of a signature, a valid search warrant to the provider.
I apologize. I cited the facts from Jane versus Sprint, which is the second case I will get to. Under Friedman, you were absolutely correct. The police officer submitted documentation which was unsigned by a judge, which made it look like it was a search warrant, but it was clearly not signed. In that situation, the government argued that the provider provided it voluntarily on our own under 2702. What the case actually goes on to say is the police can't invite the error by submitting this incomplete affidavit or incomplete search warrant. You can't provide or request the error, and then when they come back to it, say no harm, no foul. This court has repeatedly held defense counsel can't invite an error, stay silent, and then benefit from it. The same thing was argued in Friedman, and that was the law. It simply said in Friedman, you can't invite the error and then come back and benefit from it.
But let me ask you this, that we talk about what the provider understood to be as an emergency circumstance. And in this instance, the fax request to the provider said, obviously the suspect presents immediate danger to any law enforcement officer. At that point, the provider has information, or at least a representation from law enforcement saying this is urgent, there is immediate harm that's in stake, that the provider could reasonably rely upon. Does that not comply with the requirements of 2702?
Justice Melton, that's a fair point to say if you had any evidence as to what the provider relied upon. The fact is the murders took place on the 20th, the request was made on the 21st, the compliance was done on the 22nd.
This fax is in the record, right?
The fax is in the record, but we don't know how the phone company perceived it. Who looked at it? Did anybody look at it? Was it some clerk that just on its own always complies with these things? We have no information as to say why.
But we know that that's what the provider responded to.
Yes, Your Honor, but we don't know. Go ahead.
It is evidence of what is in the mindset of the provider. If this is what they're responding to, you're saying it's an open question of whether they actually believed anything that's in the request?
It certainly would be an open question because some people may say, well, that was 2 days ago, maybe it doesn't apply. I would also argue that what crime that's unsolved doesn't have an emergency exception. My house was burglarized a few days ago, and if it was up to my wife, they should still break into the defendant's house and go find everything, and it's been 3 months. The question is the law doesn't allow for it. What 2702 in its definitions and Georgia law in its definitions say, there has to be a reasonable basis for the provider to think there's some ongoing type of emergency.
Where do you get that?
Your
What
Honor,
you just said, tell me where you get those words. Because 2702 doesn't talk about the provider, as I recall, having a reasonable basis. It says in good faith, right?
It has to have a good faith, reasonable reliance, Your Honor.
It doesn't say, it says, to a government entity if the provider in good faith believes an emergency involving death or serious injury requires disclosure without delay.
Correct, good faith, I apologize. What I'm
Now,
saying.
there's a big difference, because reasonable means we get to decide whether their good faith was reasonable or not, but good faith just means subjectively they acted in good faith rather than bad faith.
I agree, but you have to take that in conjunction with the Georgia law, which has given her stricter protections. Georgia law also gives you a remedy of suppression under 1611-67. Federal law, as to this point, does not give you any remedies for violations of those statutes. When you look at the federal, you're correct. There's got to be.
You say the Georgia law is stricter, but the Georgia law just says if it complies with the provisions for access set forth by the laws of the United States.
Yes, Your Honor, but if it also says in 1611-66.1b that you must first comply with those laws and then the provider will turn those over, specifically in 66.1b, Your Honor. And so what I'm trying to, I guess doing poorly job is to describe to the court is we simply say you look at the procedural aspects. 2703 is the critical aspect you look at. It says if you want these records, specifically transactional records, cell records, anything of that nature, you have to, 1, get a court order, B, get a subpoena, or 3, get a search warrant. That's it.
That's if you want to be able to force the provider to give you the records. If you want to be able to require the provider to give you the records, you've got to have one of those things. But if the provider wants to give you the records under 2702, it just has to have a good faith reason to believe there's an emergency, right?
I can't argue with that, Justice Namias, because now we're speculating as to what the provider wanted to do. If it wanted to turn them over and we had some evidence of that, we could use that exception under 2702.
So you're saying the only issue here is a question of fact-finding about what the provider, why the provider did it, not if the provider had gotten the same facts and they called a witness, and it was sent to the legal department of the provider, and they called a witness from the legal department who said, we got this, we believe that there was some ongoing emergency, and in good faith we provided it, you would lose.
I don't necessarily agree with that, Your Honor. That's one of the factors you look at. Georgia law specifically says you have to look at federal, and it gives you 3 reasons. The state gave us no explanation on the record as to why they couldn't simply walk across the street the day after the murders took place, pick up a pre-signed certified subpoena that every clerk of court in every county of the state has, or pick up the phone and talk to a judge and say, we're going to do this. Is that okay? And get some type of oral authorization. There was no reason ever given. There was no reason present. There is no exigency, so we can argue that the provider may have thought this, may have thought that. One of the questions you would ask on cross-examination is why 2 days after the fact of a murder do you think there's an emergency? What exactly is going on? Who specifically, provider, is going to get hurt? If those questions can't be answered properly, then we're back into this exact same situation where the records need to be suppressed. So what they've done is by keeping the records silent, the questions that are coming is shouldn't we presume this, shouldn't we presume that, and we just can't. Simply saying that obviously a law enforcement officer may have some danger by trying to apprehend a criminal, it's not enough. Every traffic stop could give you that same type of situation. We talk about officer safety in this court repeatedly and say you can do pat-downs, you can do these things. Officer safety isn't going to be enough, and we have no evidence on the record as to what this wireless provider specifically thought. Why 2 days later there's a good faith ongoing emergency?
Is it 2 days or 2 days when they provide it, but 1 day when they get the request?
Yes, Your Honor, they got it, but just like in...
What's your best case? Because Friedman, I think it's weeks later or that they provide it, so it kind of undercut the argument that the provider thought it had any urgency. Here, it seems like, having dealt with a lot of cell phone companies and tried to get records,
Yes, sir.
turnover of records within 24 hours is exceptionally fast, even in like a Centennial Park bombing case. So I mean, your argument that 24 hours turnaround suggested they didn't think it was important is hard to understand.
I understand, but we're speculating, you and I, Justice Namias, in this situation because we don't know what they thought. 1 day could be too much, 1 hour could be too much. If you look at the pure definition of emergency under 2702 and marry it with the Georgia law as to what an exigent circumstance is, it doesn't exist. We're missing, in my opinion, maybe a forest for the trees argument. All they had to do was go get a piece of paper and fax it. Instead, they waited however many hours after the murders took place, faxed off a request saying, obviously law enforcement is in danger if we approach this dangerous person. That is true in every single criminal case. Short of the defendant just staying there saying, I did it at the scene, you would have no Fourth Amendment protections for anyone if that was the standard that we're willing to set. The case law in OCGA 1611-66.1 doesn't provide for that. If we go to another federal case, Jane versus Sprint, which came down out of California in 2009, there the victim was kidnapped and somehow got to the police, and that's where the U.S. attorney provided evidence, even though it was hours and hours later, that this is why the Sprint company thought that it was going to be a valid emergency. And these are all civil cases, and that's where the 2702 analysis 99% of the time comes down, is protecting the providers from suit. When you look at the criminal cases, everything cited by the government where it says you have no Fourth Amendment privacy protections in your cell phone records predates this statute. And the federal cases that they cite that don't predate it all have a valid subpoena or a search warrant, so the whole privacy argument becomes academic. And so to me, those cases were misleading. Unfortunately, the trial court accepted all those verbatim and recited them in its order. And there's nothing we can do about that except get it reversed, because that was in error. And
Counsel, to get suppression under 67, it's not enough to have a violation of the Stored Communication Act. You have to have a violation of state law, meaning in this context 66.1, correct?
Yes, Your Honor.
66.1 on its face does not actually prohibit anything. It provides some avenues under federal law for law enforcement officers to go get information, the disclosure of which would otherwise be prohibited under federal law, correct?
Yes, Your Honor.
So it's your argument that 66.1 implicitly prohibits law enforcement officers from getting information except as otherwise provided?
Yes, Your Honor. It specifically says you have to follow the federal statute as the procedural remedy as to what you can get. And when I cite the court to 2703, it couldn't be more black and white, where it says you got to do one of three things. And that's
so your position is that 66.1 impliedly, it is a violation of 66.1 for an officer to get information except as specifically authorized in 66.1.
It is, Your Honor, because when you look at 66.1 subsection D, it provides a penalty that the officer could be held in contempt if he violated this code section in the way he behaves.
Under 69, he could also be guilty of a felony for any violation of 66.1 except for subsection D, correct?
Yes, Your Honor.
I find that fairly remarkable. Are you aware of any other provision of state law that makes conduct a felony based on an implied prohibition?
Your Honor, Justice Blackwell, I wouldn't argue that it's an implied prohibition. It says follow the federal law, and the federal law says you must do one of these three things under subsections B and C of 2703. It doesn't give out any exceptions. We have a quasi-civil exception under 2702 that we've talked about with Justice Namias, but every single case, when you look at that, will be dealing with when you're suing the company saying we had a good faith basis to believe it happened, and there was evidence presented. That's why we cited with regards to Friedman, because it says officers can't say we just sent him a letter. Essentially, that's what it said when they argued it, saying we sent a search warrant that was unsigned. It's essentially just a request. Please give us a request. And the federal court in that situation said you violated the law by making that request without following the procedures that were out there. There was no reason not to follow those simple procedures that are out there. And the fact that you had AOL essentially commit an additional crime by turning those over doesn't get you off the hook. Or even if AOL was duped into thinking it was voluntary, doesn't get you off the hook because you initiated it. There's no evidence here that the communications provider, in Mr. Registe's case, on its own, read the newspapers and felt bad and said, I'm going to turn all this over. A request was made in violation of 66.1.
It's a request. 66.1 is require. If you want to require evidence to be turned over, there are certain ways to do it. But I'm trying, to follow up on Justice Blackwell's question, you seem to be, your argument seems premised on the idea that these are the three ways and only the three ways you can get information. But, for example, there's a fourth way, which is 2702, and I could probably come up with 5 or 6 other ways, like plain view during the execution of another legal act at a cell phone provider's establishment. And by your argument, that would be a felony.
It's what the statute says. You can't run around the statute's 3 requirements and simply say, we just made a request. That's like saying we just walked up to the house and the gate was open, so we went to the backyard and looked at this. There's no plain view issue. They knew exactly what they were asking for. They knew exactly how to do it, and we know that because 2 months later, on September 19, 2007, they went and got the court order with no supporting affidavit or any information as to what the court had available when it issued the order. Thank you.
Counsel. Ms. Murphy?
Thank you. If it pleases the court, this was a, let me just explain a little bit how I'm on this case, just to get where we are. I was appointed on this case as a...
Microphone, closer, thank you.
Okay. I was appointed on this case because of a conflict, and the conflict relates to one of the witnesses on the case, Lawrence Kidd, who in the fact pattern as to how we achieved this phone number, the acquisition of this phone number, he was represented by an attorney who was partners with the soon-to-be elected DA. Mark Shelnut was the counsel for Lawrence Kidd, who provided to the Columbus Police Department the phone number, the cell phone number in question. So that's how I'm now involved in this case as a conflict. When we first argued this case in the Superior Court, a large extent of the oral argument in court was regarding standing. That was where we spent the largest chunk of our time. And the court, in its order, found that there was no standing of Mr. Registe, the defendant in this case, to litigate this under all claims here. It has long been held to this court that we're talking about cell phone records. We're not talking about content of phone conversations. We're talking about business records, that those business records are the property of the provider, the third party, and not the individual, in this case, the defendant, Michael Registe. It's long been held that by this court as well as the U.S. Supreme Court, and those cases have been cited. Those cases are still good law today, no matter the change in our technology, or as the defense counsel has talked about, the changing in the statutes. And that fundamentally is the issue here, as the court honed in on in the Superior Court level, trial court level, that there was no standing under the Fourth Amendment as to any privacy issue. And when we look at Chapter 1611 and the statutes that we're referring to, the article is regard to privacy. That's a personal standing to that. In the last brief I saw from the defense, they want us to ignore the Fourth Amendment. They said, and they urged this court to ignore the Fourth Amendment analysis when we go through these, and that can't be ignored. They're all interrelated.
But let me make sure I understand you.
Yes, sir.
You're saying that the Fourth Amendment standing analysis means that only the provider's records have constitutional stake.
I'm arguing, Your Honor, that the defendant has no standing.
Right, because it's the provider that has standing.
Yes, Your Honor.
Does that apply the same way to the statutory analysis?
Well, when I read the statutory analysis and it's arguing privacy, that's a privacy that belongs to an...
Where do you get arguing privacy from?
Well, labeling it privacy. The article is labeled under privacy, Your Honor. If you, 1611...
So you're implying that
I am.
the statute equals the Fourth Amendment based on the name of the article?
Well, when we're talking about privacy, if we're not talking about a personal interest, then what, I guess my question to myself would be, what are we talking about? What privacy? The argument...
Statutes can give you standing far beyond constitutional requirements.
I understand that, but the issues here in the case law we've seen as applied to matters of phone records have always said that the documents belong to the third party and not to the individual.
The Georgia case law or the federal case law? The federal case law is just talking about the Fourth Amendment.
Right.
The Georgia case law that you cite was talking about a version of this statute that existed that only applied to the contents of communications, and so the statute didn't even talk about cell phone records. So since cell phone records became part of the statute, do you have any case law?
No, as far as calling them cell phone records, no, Your Honor. What we have are phone records, which are the same information, which are what phone numbers were called and received. So while we're talking, maybe I'm misunderstanding Your Honor's question.
As I understand this court and the Court of Appeals precedent from
Yes.
the early 80s and
Yes.
70s, we said you don't have standing under the Fourth Amendment, which I think is generally conceded, to get at third-party records. And
Correct.
under the Georgia statute, you don't have standing because the Georgia statutes are only about the contents of records.
Correct.
In 1993, after those decisions, this statute was created to give protection of some form to cell phone records, not contents, which are still there, but records.
Exactly.
Since the time we have a specific Georgia statute to give you some kind of interest in cell phone records, do you have any cases that say that individuals don't have standing to
No.
challenge a violation of the statute?
No, Your Honor.
Okay.
But our argument is premised still, while I understand the change in what Your Honor is saying, the law has still been in place. And as recently as 2012 on the Hatcher case in the Court of Appeals, where we're talking about a third-party doctrine assessment,
Counsel, Hatcher is a pure Fourth Amendment case. There's
Yes.
no reference in Hatcher made in any of the briefs to the Court of Appeals to 1611, 66.1, or 67.
Yes, Your Honor.
So that's a pure Fourth Amendment analysis
Exactly.
under the old law.
Okay. Exactly. The state's position, and I guess we still, is that they're intertwined when we do this, that they can't really be separated out. We take assessments and we go down the different traveling, but that they're not exclusive when we do the assessment.
Well, to give you another example, if this were a Fourth Amendment case or a federal law case, you would win because there's no exclusionary remedy for a violation of the federal statute. But the Georgia statute provides some sort of remedies. So it seems like the Georgia statute is not congruent with the Fourth Amendment.
Well,
But maybe you need to talk about why you prevail under the Georgia statute.
okay. Under 161167, and Your Honor, I understand where we're talking about older cases, but we don't have anything as of yet that says these older cases are not applicable to this situation. In Hartman versus the state, 266 Georgia 613, 1996 case, the defendant was trying to suppress a tape recording statement. It was a recorded statement. And in that case, this court clearly stated those statutes only apply to intentional interceptions of conversations. I understand that we're talking about a change in calling it cell phone records versus the old toll records, but this case clearly says that the statute only applies to intercepted conversations. We're not talking about conversations, we're talking about telephone records, if we want to call it cell phone records, but we're still talking about telephone records, the numbers
But
called.
when they said the statutes they were talking about at that time, did they apply at all to cell phone records?
No, Your Honor.
Okay. So I just don't understand how you get from us saying something about a statute that says nothing about cell phone records to mean the same thing as to a statute that now talks about cell phone records.
Well, because, Your Honor, the cell phone records, as it was in the evidence about what was achieved, was simply the phone numbers called within a period of time. So when we look at the federal statute, as the court brought up in 18 USC 2702, as the officer, Detective Jackson, presented in his cover sheet to them that this was an emergency, immediate danger, with two individuals deceased, two young men deceased in a motor vehicle at about 9:30 in the evening, with suspect unknown, whether anybody else was involved, could possibly hurt unknown. presented this to the cell phone company with that particular information in their request, and they received it in very short order, the limited information they requested to satisfy the section 18 USC 2702C4, that where the provider reasonably believes there's an emergency involving immediate danger of death or serious physical injury. They may provide this, and so they did comply with that. The 18, as the court is well aware, is that 2707, correct, we don't have a suppression of evidence even if the code section is violated. So the Columbus Police Department, in their exigency or emergency situation, did comply with the statute, with that exception. So we don't have a violation of the federal law in regard to cell phone records.
Ms. Murphy, are
Yes,
you saying that there is no greater protection under the Georgia statute than under the federal law? Or are you saying it's really coextensive, that the two?
I'm sorry, Your Honor, I didn't hear the last
Saying there's no more
portion.
protection under Georgia law than there is under the federal law?
I'm coming from it, from a review of it, that Justice Namias obviously has picked up. It's from a historical end of it. And while there are no case law that specifically in regard to cell phone records, there are legions of cases on telephone records. And the state would urge the analogy of those records in this situation, because we're not trying to achieve anything more than what we have always been able to obtain with getting telephone records. We just now have it called, we now carry a cell phone versus the landline where it's hooked on the kitchen wall. And under the law that the state would urge is still applicable, yes, the state feels that under 1611-67 that these things do not go to phone records, be it cell phone or landline, but simply conversations.
Let me ask you, if I understand Mr. Arora's argument as to 2702, he argues that that's usually used in civil context as a safe haven for providers who provide information. Do you have any indication that it is used to justify the search of materials to be used in a criminal context?
I believe the statute says for law enforcement, Your Honor, if I pull the statute and read it, I believe it's prefaced for law enforcement to be able to use it. I believe that's what the section 18 USC 207C4 is in regard to law enforcement's achieving it.
Or governmental entities.
Or governmental entities, yes, Your Honor. So are there any other questions? We just urge the court to maintain the court's order.
Thank you, counsel. Madam Clerk, will you call